And so this comes on for a couple of things. My understanding of what's going to happen today is this comes on defense motion to suppress based on the search warrants and based on the four corners of the search warrant, is my understanding, asking to, due to material omissions or misrepresentations, suppress evidence seized as a result of the search warrant. We'll get to that in a second. Before we do that, though, I do want to put something on the record. Honestly, I didn't expect to be here today, in that this was initially, I just learned about this late yesterday afternoon, and because there's been some things filed back and forth, and I just want to put on the record, and I don't think we need to get to argument on this issue. The state had filed an affidavit. This case had been heard, just back up here a little bit. This case had been, there had been a couple of hearings. I think Judge Buckley heard probable cause. I know I heard, had a hearing in this case, made some rulings. And then internally, the case was assigned to Judge Wilcox, who was going to do the trial. She was getting ready for the motions here today. And then the state, I think yesterday, filed an affidavit of prejudice, which is their right to do. Mr. Cover filed an objection to affidavit of prejudice, and he indicates in his objection that it must have met the requirements of Rule 8.9. It must have been filed before Judge Wilcox made any discretionary ruling, and I'm not aware of any that she has made. It must have been filed within 10 days of arraignment unless alleges a particular incident, conversation, which it didn't. And which, but I think if you look at 8.9 and you go to the end of the rule, which I think is the relevant sentence in this particular case, in multiple judge courts, or when a pro tem, which we are, or when a pro tem or visiting judge is designated as the judge, the 10-day period shall commence on the date that the party has actual notice of assignment or reassignment of the to a designated judge. So I would find that that 10-day clock starts to tick when the state found out that she would be running the trial. And so the affidavit of prejudice is going to be accepted, and you're stuck with me. And so I'm going to be handling the case in this case. And if you want to create a record, I know you've objected to that. If you want to create a record in that regard, but I think affidavit of prejudice is just it's a matter of right in terms of defendants. I won't say all the time, but not uncommon for defendants to file them, and they just get, again, they have those as a matter of right. And I think the state has chosen to do that. And it appears to me it was done within the context of the rule, and so I'll be handling this case.
Your Honor, we have no objection on that. We do anticipate we will be preserving some issues for appeal, but this will not be one of them.
Okay. And then, the next thing we're on here for, again, we talked about motion to suppress. I noticed that Mr. Cover, on behalf of the Lattins, had filed some motions in limine. And again, it'd be my preference to deal with all those motions in limine, both from both sides, all at one time. I don't want to do those piecemeal. There might be a pretrial conference. We could talk about setting a court date for a pretrial conference when all motions in limine, which deal with the trial, can be dealt with at once, if we get to that. But I don't think that makes a whole lot of sense to do these motions in limine, which basically set out the rules for the trial piecemeal. But that's what I'm going to, and again, we'll hear the motion to suppress. I reviewed all the documentation and briefing that's been filed on both parties, and we'll go forward on that. But yeah, motions in limine, I would like to have those wait until they're all pulled. I'm assuming, maybe incorrectly, assuming is always a dangerous thing. I'm assuming I'll see some motions in limine from the state. Mr. Cover and his motions in limine said first motions in limine, and anytime there's a first, there's usually a second. And again, it just makes most sense for those to be dealt with all at once. And so with that, we can proceed to the motion to suppress. Arrange my notes here.
Counter, if I may.
Yes.
This is my first appearance in this case. Chuck David, the prosecuting attorney's office for the state, as well as Mr. Young.
Okay.
I'll be assisting him. There was also a motion filed for immediate return of the animals. Questions whether we'll be addressing that today as well.
And I didn't see that, and again, I'll say it again, it was handed to me right at the very end of the day yesterday, and then and I didn't see that was noted on to be on for today. was it or not? And I have not reviewed any, and I saw that in the file, but in getting ready for this hearing today, I was prepared to deal with the motion to suppress, and like I said, I had the motions in limine. Was that on today?
Your Honor, we had intended that it had been on today. My understanding is it had been properly noted, but Ms. Garrett did indicate that according to the court, it was not properly noted, and so that it won't be considered. However, the petition for immediate return, which brought this case to commence, is right according to RCW 16.52, and in that emergency motion to return the animals, it contains filings that you asked for in the during our last appearance here. You will see the results on September 12th from the inspection of the animals at Hook Animal Rescue, as well as other documents that are as the herd check that you asked for, Your Honor.
Yeah, honestly, I didn't consult with Ms. Garrett. I just looked to see what was on here today. This was given to me. I told there was going to be this hearing. I reviewed the motion to suppress. I know that there's confirmation set for next Wednesday. I've cleared when that makes most sense to handle the motions in limine. I've made arrangements where we're all going to be in courtroom number 1, which is a much bigger courtroom, so hopefully people won't have to stand. And my suggestion would be to deal with all that at that time. And I know that you're impatient, and your clients are even more impatient to get that dealt with. But that would be my suggestion in that regard. Frankly, I just haven't reviewed those things. I saw they were in the file. I didn't take the time to go through all of it.
We'd just like the court to know that if you review those records, that those goats are suffering not only sodomy from the other goats, but also dog attacks now, according to Dr. Michael Clark. So we would appreciate it if the return of the goats could be addressed immediately.
Just a second, you can finish. He can, I will review those. I've indicated to you that I haven't. I'll certainly be on top of those by next Wednesday. Probably I'll review those over the weekend. But again, it's not on the calendar here. It's my understanding today. And I'm just not prepared to deal with that right now.
Thank you, Your Honor.
So motion to suppress. And then, this was a motion to suppress the search warrant. I've reviewed, there is a in the pleadings, there's a transcript of the search warrant when Deputy Nastansky applied for that for Judge Murphy. There's some pleadings that were filed on behalf of, from Mr. Cover on behalf of the Lattins. Is testimony necessary that we're going to proceed here today, or is this going to be argued off the four corners of the affidavit based on the documentation? And Mr. Cover, it's your motion. I'll hear from you.
Yes, Your Honor. We see Deputy Nastansky in the room. We would like the opportunity to examine her today, if possible. We believe it is possible. And we believe that it is crucial to you, for you to have that information after reviewing the pleadings, so that you can judge the veracity of the material falsehoods and omissions.
Mr. Young?
No. Your Honor, what we're reviewing is whether a search warrant and affidavit doesn't require testimony. I don't think we should make any showings that would require testimony.
Your Honor, Deputy Nastansky is on the state's witness list,
right,
and she's present.
And at the time when we go to trial, certainly she'll testify, but hang on just a second. And so, Mr. Cover, you made the motion to suppress based on an inadequate search warrant. Typically when you're attacking those warrants, by the way, before we go any further, I know that there's been some permission to, frankly, I find that cell phone a little disconcerting. And I know I don't object to any sort of filming, and that had been requested before, it had been granted. And I see there's a camera going there, which is fine. And perhaps I should have addressed that, and I know the Olympian's here with a still camera, which is also fine. But, and then what I'm going to have you do then is move to the back so you don't obstruct people behind you. And I have no objection. I'm not precluding anyone from filming with the appropriate request. You have some identification, you can do that. But I wanted to do that in a manner that doesn't, and again, I find it a little disconcerting. It goes up, it goes down, it goes up, it goes down. You have people behind you, and so I would have you move behind, and you could have an unobstructed view from either back in the corner, or maybe back behind there underneath the screen, and then you're free to do that.
I'm done, Your Honor.
Okay. Or that, which is just as good. And so, as I was saying, sorry for the interruption. I think this isn't a motion to suppress where there was an inadequate stop or anything like that. I think the way my preferred course of action is to review the four corners of the affidavit, examine and hear argument on what you say was omitted or falsified, and make a ruling in that regard. So I'll hear argument from you. I don't think we need testimony at this time at this hearing. I'll hear argument from you. I'll hear a response from the state, and then Mr. Cover, I'll give you the final word. So go ahead.
Thank you, Your Honor. First, I'd just like to ask, I provided a bench copy of the Declaration of Justin Cover of October 5th, 2017. Did you receive that bench copy, Your Honor?
It's right here, somewhere in this stack.
Outstanding. I'm going to be referring to that at length during my presentation here, Your Honor.
Your Honor, if I can make an objection at this point, it depends on what he's intending to use this for, since it was just filed as part of it yesterday. If it's something that I should probably have someone else review to determine the factual accuracy of what it is, thank you.
Okay, did you get a copy of it?
I got a copy.
Okay.
Your Honor, I
Okay, hang on
also...
just a second. If there's an objection, I get to make a ruling on that, and then I'll come back to you, Mr. Cover. Given that the state has a copy of it, Mr. Young, I'm going to overrule your objection at this time. I'll allow Mr. Cover to argue from that. And just remind you, Mr. Cover, I've read it, so you don't need to repeat the whole thing to me. It's in the court file, it's part of the public record, and so go ahead.
Your Honor, we thank you for that very much, and we appreciate how quickly and how prolifically that you read our record. Your Honor, now in my brief, I said that the most crucial material falsehood offered in the warrant was that Deputy Stansky did not inform Judge Murphy that the complaints, either 5 or 7, depending on whether you read the affidavit or the report, were unfounded. Last night, while I was going through the record, I discovered an even more egregious material falsehood. And the record that I have provided in the Declaration of Justin Cover outlines the facts of that. Your Honor, I'd like to direct the court's attention to page 000289 in the Declaration of Justin Cover. That page, along with page 000288, provide a record of an email exchange between Deputy Nastansky and employees of Chambers Prairie Animal Hospital. Looking at page 289, you will see at the bottom, because he's going in reverse order, the very first email exchange was at 2:41 p.m. on June 14th. And you will see there that there indicates that there was an attached file, DebbieLatinAnimals.pdf. So this is a record of records being sent to Deputy Nastansky by email before she sought the warrant. Now, if you look up, there's a message that's split between page 288 and 289. It's from Deputy Nastansky, sent it on June 14th, 2:51 p.m. It reads, "Thank you. Do you see anything in your records or notes about hoof rot?" It seems to indicate that she was going through the records that were sent to her, and she had questions about whether there was any sort of record about hoof rot in there. Now, on page 288, just above where it says "from Carrie Nastansky," you will see the reply from either Davy or Dobby, D-A-V-I, at Chambers Prairie Animal Hospital, where it says, "Here are some records that we found in the paper portion. I hope this helps. Let us know if you need any information." Again, that email was sent at June 14th at 3 p.m. Now, that was the end of the email exchange for that day. After that, Deputy Nastansky went and got her warrant. She went to the Lattins' home. She took their goats. Okay. Now, the next exchange happened on Thursday, June 15th, 2007 at 3:40 p.m. So that's the next day. That's shortly before she read her report. "Thank you. Are these the only records then?" So she was looking for more records then. She obviously went over the veterinarian records that were sent to her, had knowledge of them, and then asked for more. To which, just above there, at 3:50 p.m. today, seeming to indicate June 15th, 2017, yes, those are all the records we have. Your Honor, this indicates that all the veterinary records that she received from Chambers Prairie Animal Hospital were received by June 14th, 3 p.m. Your Honor, I will now direct you to the remaining pages of the Declaration of Justin Cover of October 5th, pages 000290, 000291, and 000292. If you look at page 290, you will see that we have a history of care from Chambers Prairie Hospital on August 25th, 2014. And there's visit after visit, going up through 2015 and into 2016. And then if you look at page 291, you will see that the latest visit from Chambers Prairie Animal Hospital occurred on May 13th, 2016. Page 292 indicates additional care that occurred in 2015. With all that in mind, we now move to the affidavit. This is the sworn affidavit that Deputy Nastansky gave to Judge Carol Murphy under oath. And at this time, I'd like to direct the court to line 18 of page 309. Again, that's line 18 of page 000309. And it states, and this is Deputy Nastansky's report, her testimony in support of the warrant. I spoke with both veterinarian offices, meaning Deschutes Animal Clinic and Chambers Prairie Veterinary Hospital. The last time that a goat was seen for any hoof-related issue was in 2012. Debbie tells me that that's not true. However, that's what their records show at the veterinarian offices. Your Honor, according to this email, she had these records. Not only did she have record of veterinary care that was occurring from 2014 through 2016, it's very clear that it's filled with treatment here, Your Honor. We have euthanasia of a goat, we have penicillin and procaine, we have thiamine hydrochloride.
What's that for?
You know, Your Honor, I don't know. I'm not a veterinarian. But Deputy
Hang on
Nastansky...
a second. I'm not either. But then, when you said, if we don't know what this is for, isn't that consistent with, she doesn't have any information about a hoof-related incident issue since 2012? Because it doesn't appear to me like these are hoof-related treatment.
Your Honor,
Okay.
It is hoof fraud.
Which is the important report, but go ahead, go ahead.
Yeah, just one moment, Your Honor. You know what? Doesn't matter. It's okay. Your Honor, by saying that there's no issue for hoof rot, it doesn't make any sense that the veterinarians would go through all this care and then ignore the hoof rot. If we are going to say, well, it doesn't matter that there's no treatment for hoof rot here, then we are presuming that Chambers Prairie Animal Hospital looked at these goats and cured all of these things and then decided to let the hoof rot languish. That defies reason, Your Honor. Even if there is no treatment for hoof rot, these records are not consistent with the representation that Deputy Nastansky made to Judge Murphy. If Judge Murphy would have known there would have been veterinarian treatment going on from 2013 through 2016, we offered to the court that she would have made a different decision. We offered to the court that if a Frank's test were applied and these material omissions were added in, that there wouldn't be a finding of probable cause anymore, Your Honor. Judge Murphy thought, based on the affidavit that was sworn by her, that there was no treatment between 2013 and 2016. That's what she made the judge think. So it doesn't matter whether or not there's any sort of deal on hoof rot in here. Not to mention the fact that Deputy Nastansky is not a veterinarian either. She looked at this, decided to ignore it, and then told the judge that there's been no treatment since 2012. That is a material omission, Your Honor. And we ask that you apply that material omission to the Franks test. This is rank dishonesty from a deputy sheriff, Your Honor.
Objection, Your Honor.
Sustained.
Thank you.
You can, let's refrain from the personal attacks, Mr. Coburn.
Thank you, Your Honor. Your Honor, she also adds material falsehoods on her experience. In the affidavit, Deputy Stansky told Judge Murphy that she had nearly 25 years worth of experience. In her report, she backpedals. Now she's had 23 years experience owning goats off and on. We still don't have the true number of what her experience really is. And she left herself an out in that report so that she can say yes to any story that fits the evidence that Cover finds later. If Judge Murphy would have known that, oh, maybe it's 25 years experience, or maybe it's 23 years, oh, it's not even that much, it's some mystery number that we don't know yet. We apply that material falsehood to the Franks test, and we don't have probable cause for this warrant anymore. We still don't know how much experience she has. And remember, this woman removed unweaned baby kids from the goats, from their mothers.
Address your comments to me, please, okay?
Yes, Your
I
Honor.
see you making gestures over to the side of the courtroom. Move towards me, please.
I have your ruling, thank you, Your Honor. So, whether it's 25 years experience, whether it's 23 years experience, not to mention the fact that the animal cruelty officer, who has had, according to her, extensive training on handling animals, she doesn't seem to know the difference between a ram and a ewe, as evidenced by her report. She says that the male goat's a ewe. That's not a person with 25 or 23 years experience with the animals. Now, moving to my last material omission. Experience with goats. Deputy Nastansky omitted that the complaints were unfounded. If you read the affidavit, you will see that she told Judge Murphy that there were 5 complaints against the Lattins for hoof rot in the period between 2014 and 2016. However, in her report, she says that most of those complaints were unfounded. I really wish she'd get on the stand so she could tell us which ones were unfounded and which ones had some basis. Because she certainly didn't put it in her report. She certainly didn't put it in her affidavit to Judge Murphy. That is a material omission. And I would like to add at this time, Your Honor, that unfounded, the reason they call it unfounded is because that is one of 10 disposition codes that are available in the computer automated dispatch for police officers to close out complaints in Thurston County Sheriff's Department. Unfounded means there's no basis to bring a charge. Yet that seems to be the bulk of the state's case, Your Honor.
Evidence of this.
Your Honor, that appears
It's argument, I'll allow him to go.
Your Honor, that is the bulk of the state's case. She never told Judge Murphy that most of these complaints were unfounded. She wound up with another number later. And only in her report, only after she got the warrant, only after she took the goats, and only after my clients were being incurred costs for the care of those goats by the state, only then did she add to her report that the complaints were unfounded. If Judge Buckley were here, he could recall when we were at arraignment and Ms. Weevedaw attempted to use those complaints as probable cause for this crime. But Judge Buckley didn't sustain probable cause because he knows, like all of us know, that
Judge Buckley did find probable cause.
only after Ms. Weevedaw reached into the RCW and read the magic words, because what was contained in the report about the complaints was not sufficient.
I just want to put on the record you found probable cause.
Probable cause was found. Again, we're just talking about the warrant here.
Yes.
So go ahead.
My point being, Your Honor, is that these unfounded complaints cannot possibly militate towards any finding of probable cause in this case. So, that being said, we have asked for a Franks hearing. Your Honor, we're asking you to add the material omissions that I've outlined in my brief and on the record today. And I'm asking you to include the material omissions and to remove the material falsehoods and remove the warrant. Because we believe, and we have pled, that when you apply the Franks test, which we are entitled to, for which we have made a material showing of fact, a substantial preliminary showing, this warrant will not pass muster. We ask you to apply the Franks test, Your Honor, and with that, I reserve the balance of my time.
Thank you. Mr. Young?
Thank you, Your Honor. Your Honor, defense counsel puts between the omission and the falsehood. I'll start with falsehood, Your Honor. The first thing he's indicating his material falsehood is that Deputy Stansky, 23 or 25 years experience. He's indicating that that's falsehood. Now, first off, Your Honor, it's not material. Whether she's had 23, 25, 10 years is not material when it comes to the basis of establishing probable cause. And first to lay out the standard regarding misrepresentation, the defense is supposed to put on the substantial preliminary showing that there was a misrepresentation that was made deliberately or recklessly, and misstated information was material or relevant to the magistrate's determination of probable cause. We don't have any of those in here, Your Honor. You can't say that 23, 25 years of experience when she's informing the court in her warrant. It's not a material falsehood in here, Your Honor. And also, there's absolutely no showing that any of this was deliberately or recklessly given. And you can tell that she is indicating that it is nearly 25 years. Your Honor. The defense's only offer in this is to perhaps an unqualified statement regarding a U in the warrant, and then the difference between 23 and 25 years to report an affidavit. It's not material, it's not substantial showing, it's not reckless, there's no showing of any of these. So, Your Honor, next I'll move on to the admissions. Further to the admission, defense counsel has to show that a fact was omitted from the search warrant affidavit that should have been included, and that if it had been included, would render the affidavit insufficient to support probable cause, and they must prove by preponderance of the evidence the fact was omitted intentionally or with reckless disregard for the truth, and commit a fact of the material to the issue of probable cause of the search. Now, first he hasn't put on any information to show that this was reckless, intentional, without regard for the truth. First, to address, Your Honor, of these, it's a falsehood in the records. Claim there's a falsehood in the records, and I was going to point to the same thing the court already recognized. The affidavit says that I spoke with both veterinarian offices. Last time that a goat was seen for any hoof-related issue was in 2012. That's what their records show, pointing to records. At the veterinarian offices, she has no independent record of her own to prove otherwise. The defendant's own submission, Deputy Stansky is requesting, is there anything related to hooves? The response is, you have all the records. She follows up again, doing her due diligence, is there anything else? If you look through, just from my own cursory Google search on here, Your Honor, and in my candidness to the court, I didn't see anything that specifically showed that any of these things were related specifically to hoof rot. It could have been to udders, could have been, I didn't see hoof rot pop up when I was searching for some of these items. That was after receiving it, just on the eve of this hearing. And to point out that, to claim that there's a falsehood when there's substantial records, when that's all the records they have for 31 goats, that appears to me that could have just been one goat on an emergency situation. There's no showing that veterinarians came out to the farm, maybe they brought the goat to the hospital. All it is just like the court observed, some references to some drugs that were used that did not look obviously related to hoof-related issues. And again, it is on the defense to prove these allegations in relation to the warrant. The next is regarding the calls for prior deputies that appeared. And Deputy Stansky talks about those calls. She says she even indicates what was informed to the deputies on those prior calls. What technical code the Sheriff's Office used at the conclusion of some of those calls is not material. It's not even defined. according to his allegations, defining what the term unfounded uses. What Judge Stancy is telling Judge Murphy is that she's giving a rundown of information from some of those prior calls. There's nothing, again, to show that any of that information, any of that is material that should have been in the warrant, it would have any effect on probable cause. There's nothing to show that she intentionally omitted anything, or she did anything with reckless disregard to the truth. If anything, it's in her record that she's done a very thorough job, investigation, trying to gather information. She's had a search warrant for Judge Murphy. So, on those that the court has the state's motion, just the court has any questions.
Thank you, Mr. Young. Mr. Cobra, I'll give you the final word here. Go ahead.
Thank you, Your Honor. My colleague, who I respect, says that it is not material whether Deputy Nastansky has 23 years experience or 25 years experience. However, Judge Carol Murphy specifically queried her on how much experience she had, because it is material. That is what judges typically do whenever they issue a search warrant. They ask the officer what training and experience they have. She did not represent, she overrepresented, embellished her experience to Judge Murphy. Now, as to whether her actions were deliberate or reckless, we need only point to the emails, Your Honor. It's very clear that she had the veterinary records before she went and sought the warrant. So, which leaves us with one of two possibilities. Okay. Either she didn't look at the records and she went forward anyway, in which case she'd be reckless, or she looked at the records and decided that she didn't want to talk about what was going on during the period of time that the complaints were being put on my clients. So it's one or the other. We have established in the record, thanks to my colleagues, that she knew about the veterinary records before she went and sought the warrant. And remember that the standard in this case for animal cruelty is that my clients must have knowingly, recklessly, or with criminal negligence allowed substantial harm to come to the animals through a denial of care. The fact that they saw the fact that we have veterinary care going on throughout. In fact, we have records, and there's records, veterinary records in the record from 2010 going forward. So I would suggest to you that the emails described in the declaration of Justin Cover dated October 5th indicate that we have either a deliberate omission or we have a reckless omission. Now, as to the unfounded calls, it is material how she got the information. And as we move forward in this case, Mr. Gary Edwards will be able to testify as an expert witness and inform us on how the computer automated dispatch is used and what unfounded means and what the implications for that are for a police officer in the street working an animal cruelty case. So with that, I leave you with my original conclusion, that we have material falsehoods and material omissions in the record that make my clients entitled to a Franks hearing, and that when you, Your Honor, apply the Franks test, then there will be no probable cause for this warrant. I ask you to do so now, and we rest, Your Honor.
Thank you. As I said before, I've reviewed all the pleadings that have been filed by both sides with regard to this particular issue. Heard argument here, and then based on that, I'm just going to cut to the chase right away. The motion to suppress is going to be denied. It's going to be denied for the following reasons. First of all, I want to talk about materiality, and there's going to be material omissions or material falsehoods or inaccurate information with regard to the information that was in the affidavit. And obviously, if there are omissions, it can be argued, as it was, that if the omission was included in the warrant, then if included in the application, then the warrant wouldn't have been issued. Same is true as if the false piece of information were not in the application, then the warrant would not have been issued. And I don't find either of those to be present here today. And I'm going to, in no particular order, I'm going to start with the 25 versus 23 issue. And again, I have right in front of me. Again, I'm just going to quote from Deputy Nastansky's application, specifically this animal, which is a goat. I've owned goats since 1993, so nearly 25 years personally. To me, 23 is nearly 25, if you round up, if you're going by fives. So To me, that's an immaterial issue, whether it's 23, whether it's 25. I'm certainly not going to find that Judge Murphy attached great significance to that. With regard to the unfounded, there were a number of complaints apparently over the years with the goats at the Latin. Apparently some were found to be unfounded, and that was not included in the application. But I guess when I read this application, and when I have an understanding as to why this warrant was granted and wasn't addressed by either counsel, warrant was issued and this warrant was granted by what was happening on the ground at the time. And I'm just going to read some things from this particular application. It says somebody called concerned about 20 goats. They weren't walking on all of their legs. That's on that particular day, contemporaneous with the application, not some unfounded complaint a couple of years ago. And then a deputy spoke to some employees who discussed the current care that was going on at the time on the ground. And even if Judge Murphy were made aware of all of those things, as she was, if she had been told, you know, there were some earlier complaints that were unfounded, that would not have changed her mind. She made her decision, and it's like, I don't think that Judge Murphy would have said, yeah, they were unfounded, so this must be unfounded too. She might think, hey, those were unfounded, but we got the real one right here. When you have goats walking around on 2 legs, that's a problem, and it's going to be addressed. And that's how I view that's my view of the application for search warrant. And so the fact that you're correct, that issue of unfounded wasn't in there, but I don't find that as a material issue or material fact with regard to whether or not the warrant should or should not have been granted. The other issue I want to mention was the medical records. In her indication, she said that there's been no, last time any hoof-related issue was 2012. She talked about the records. I looked at the records that Mr. Cover submitted, either they came to my desk this morning, maybe submitted yesterday. Looking through those records, which apparently were available to Deputy Nastansky, I looked through them a couple of times. I couldn't tell anything about hoof rot. I suspect that she couldn't either. And so, had Deputy Nastansky said something to the effect of, yeah, I have these records, but they don't have any indication about hoof rot, or at least I can't tell. I don't necessarily think that would affect Judge Murphy's decision issuing the warrant. And so, for those reasons, I'm going to deny the motion to suppress based on an inadequate search warrant. And so that's where we're at here for today. And so again, the motions in limine, those will all be dealt with. I do want to talk here a little bit about the trial schedule, and we can talk a little bit about that and for next week. And so my understanding was this trial was initially set for
18 October.
Yeah, October 18th, and then it was moved to the 16th. My understanding also is Mr. Cover contacted the court. It indicated that 16th would not work for him. You apparently have another professional obligation, and so I'm not available for personal reasons on the 18th, and so and I wanted to know if what I was going to suggest, that I'm not going to bind anyone to, is, this case is, normally we have cases, we prefer cases to go one day in district court. This case is going to go one day. This case is going to go multiple days. It just is. And I was going to suggest starting the trial on October 23rd and go from there and just start and go from that day. And my reading of the file tells me that speedy trial expires on October 22nd. It actually goes the following day, which is October 23rd. So it's within speedy trial, but if folks agree to start the trial on that particular date, we can agree to that. That can be done by agreement as well. So I guess I see you shaking your head. And so in the alternative, then we would go ahead and start the 16th. But again, I'm just telling you that I'm just wondering if we can get to a trial date that agrees with everything.
Your Honor,
Yes.
you know, I had put it on the record over and over again that I have prosecutor duty on Mondays.
Okay.
And so when I was informed by Judge Wilcox that in no uncertain terms that we will start on Monday, I took steps that caused great inconvenience to the entire Nisqually tribal court in order to accommodate Judge Wilcox's order. So at this point, I see that the 23rd would be another Monday. That would put the entire Nisqually Tribal Court into another, we would have to deal with this whole issue again. So I would respectfully request that we commence trial on October 16th, as I was last informed by Ms. Garrett on behalf of Judge Wilcox.
We can certainly do that. Confirmation's still scheduled for October 11th, and we'd probably go the 16th, 17th. I will tell you I'm available in the morning of the 18th, but in the afternoon I am not, and then we'll just continue on after that. And so I'm assuming the state has no objection to that schedule.
So to confirm, starting on the 16th?
That's where it's set for now.
No, there's no objection, and I think when we first got the new scheduling, we may have been concerned about witness issues, but I think we...
And speaking of witness issues, and this occurred to me as this came back to me, and I don't know whether anyone has thought about this, anyone has researched this, or anybody has concerns about this. Seated in court is Thurston County Commissioner Gary Edwards. Showed up on his witness list. Does that present any sort of conflict with the prosecutor's office or me, or does that produce issues which may need to bring in a special prosecutor or something of that sort? And again, I've done no research on this. It hasn't been raised. In an abundance of caution, I think it at least should be discussed. And and frankly, I'm a little concerned about admissibility and relevance issues, but those can be addressed at a later time. I just know if I'm just raising this as an issue. And I'm just kind of talking off the top of my head here. Mr. Lippert, I don't know if you've thought about that or
I have indeed, Your Honor.
What's your thoughts on that?
While it is a sensitive topic, I do not believe that it raises any conflicts of interest that cannot be, I don't think it raises any significant conflicts of interest that would be prejudicial to any of the parties here or Your Honor in this particular instance. There are obviously political, and administrative actions that are the responsibility of the commissioners that can affect the business practices of both the courts and the prosecuting attorney's office, but I do not feel or find or believe that, first of all, it's just Mr. Edwards. If there were all three of the county commissioners involved in this would be a problem. But if it's one county commissioner, I don't believe it to be a problem. And I trust that Mr. Edwards is going to take this in stride as simply another matter in which he is a private citizen, not a county commissioner in his role as a potential witness in this case. However, having said that, I do believe that, as you stated, that there are relevancy and admissibility issues to this testimony, which we can talk about at a later time, which is why I didn't delve into that this time, because I thought we were going to deal with this today. But from the state standpoint, I don't believe there's going to be any conflict of interest that would cause any prejudice.
Do you have any comment on that issue?
Not on that issue. I got one more issue of housekeeping.
Hang on, they let me set the schedule, so we can deal with that. And then the next time, like I say, we have confirmation set for 10 o'clock on next week, and we'll be back here in courtroom number 1, and we have both parties can file motions in limine. If you want to discuss the issue of the return of the goats, we can do so at that time, and we'll go from there. You wanted to say something?
Just one thing is a matter of housekeeping, and I state this. I hope that my respect here is overflowing right now, but I respectfully object to the rulings made on the warrant today, and I ask that an exception be noted for the record under the 4th, 5th, and 14th Amendments of the United States Constitution and relevant sections of the Washington State Constitution.
I think you've created a good record in that regard.
Thank you, Ron.
I'm going to say something here for a few minutes, and that is, Mr. Cover, when we were last in court, I thought I heard you say something that stuck with me, and I kind of want to talk about it for a second. And you had said something to the effect of, and you can correct me if I'm wrong, and I could be, I haven't reviewed the tape or I haven't reviewed the transcript, but at some point you said something to the effect of, there isn't a jury around, or no jury would convict these folks. I mean, am I accurately remembering that? Words to that effect of some sort? And the reason I bring that up, because, and like I said, I have not reviewed the testimony, and I remember, that's how I remember it. I remembered it coming off the bench. I didn't think I was going to be back on this case, but it occurred to me again when I found out that I was, and I just want to make a few comments in that regard. And that is, if that was your intent or that was your comment, that's a really risky thing. Jury trials are inherently risky things. They're notoriously unpredictable, and I just want to make sure that everyone realizes that, particularly the Lattins. The state has a series of witnesses on there, including a veterinarian. You have submitted a list of witnesses, including a veterinarian. The jury's going to hear from both of them, and then the jury's going to make a decision one way or the other. And if the jury chooses to believe what the state's presenting, your clients may be, and again, I have no idea what's going to happen, and I certainly would never predict what's going to happen, but you need to be aware that, and I hope you are, I guess I would just remind you that juries are inherently risky propositions, jury trials are. And you had said that, and again, this is a highly emotionally charged case. The courtroom is full, and it's been full, it was my understanding, at every hearing. And at the last hearing, I sensed that this case here, it's a really divided courtroom. And the people who are here and supporting the Lattins, good for them. Who are here to support the Lattins, they should be. And they agree with you in that proposition that no jury would convict them. But there are others, and I know who was some here last time. There were some people wearing some shirts who could be characterized as animal rights activists. And my guess is they think the opposite. And I just want to make sure that everyone is aware of that and is sensitive to that going into trial. I'm going to tell you something else, and that is I want to make sure that the Lattins realize, and they're charged under RCW, and I'm sure you probably discussed this with them, 1652-207, and that is animal cruelty in the second degree. But in getting ready for this case, and given my experience in past cases that deal with these issues, I was reminded of RCW 1652-200, which indicates any person convicted of animal cruelty shall be prohibited from owning, caring for, or residing with any similar animals for a period of time as follows. 2 years for first conviction of animal cruelty in the second degree. So again, I'm not predicting anything's going to happen, but if there's a conviction in this case, then not only do these goats not come back, but all goats that are currently there, and there might be a discussion about what similar animals to goats are, but that would really affect the Lattins' ability to have animals on the farm. And I just want to make sure that everyone's aware of that. And like I said before, this is a highly politically charged case, or emotionally charged case. I think there's some politics involved here as well. It's also been my experience in this court that a lot of times these cases are resolved through some sort of pretrial diversion agreement. I don't know whether that's been discussed or explored. I would encourage all counsel to talk about that. And the beauty of the pretrial diversion agreement, if that's available, and I'm certainly not direct, I have no power to direct the prosecutor to do whatever, is that avoids a conviction conceivably, whereas the Lattins could go about running their business. The state's protected in the sense where conditions could be set in place, so appropriate monitoring can take place to ensure the health and safety of these goats. Maybe I'm talking out of turn, I don't know, but it's just something that occurred to me before I came on this trial, and I would encourage all counsel to at least discuss possible resolution of this case that meets the needs of all parties, both sides. And maybe I've said too much, but that's going to conclude this hearing for today.
Appreciate your guidance, Your Honor. Thank you.